The Honourable Minister of Justice and Attorney General of Canada.
Thank you, Madam Speaker, for this opportunity to speak to Bill C-46, an act to amend the Criminal Code offences relating to conveyances. At the outset, Madam Speaker, I would like to extend my heartfelt thanks to the members of the Standing Committee on Justice and Human Rights for their thorough review and consideration of this bill. Committee members heard over 45 witnesses and reviewed a significant amount of material on a highly complex topic, and I am grateful to them for their diligence and believe the bill is stronger because of their efforts. As I have indicated on previous occasions, the primary objective of this legislation is to save lives. Lives which continue to be tragically cut short by irresponsible and reckless decisions to drive after consuming alcohol or drugs. I am continually frustrated and deeply saddened by the stories of families who have lost loved ones as a result of impaired driving. Madam Speaker, mothers and fathers should no longer have to endure the anguish and heartache of burying their children following an alcohol or drug-related traffic collision. Children should no longer be orphaned by a driver's careless decision to drive after consuming alcohol or drugs. This bill aims to reduce deaths resulting from impaired driving. This bill also aims to reduce the impact of impaired driving on those who suffer traumatic, lifelong injuries caused by another person's irresponsible decision to drive drunk or high. No one should have to endure months or years of painful and costly physical rehabilitation. No one should have to give up their job or the pastimes they love due to injuries caused by an impaired driver. Despite great efforts by governments and advocacy groups to raise awareness of the dangers of impaired driving, we still see far too many headlines about these tragic incidences. Madam Speaker, there is no excuse for this type of conduct in our society, and yet, by some estimates, over 1,000 people lose their lives every year to this entirely preventable crime. Countless more are injured. In my view, it is my responsibility as the Minister of Justice and Attorney General of Canada to take any and all reasonable measures to increase deterrence and detection of impaired drivers. Madam Speaker, Bill C-46 aims to strengthen the criminal law response to both drug and alcohol-impaired driving. The elements related to drug-impaired driving will come into force on royal assent to ensure a robust drug-impaired driving regime is in place well in advance of cannabis legalization. Although it is difficult to predict the impact of cannabis legalization on the rate of impaired driving, information from other jurisdictions that have legalized cannabis suggests that there could be a slight increase. Canada needs to be prepared. The measures proposed in Bill C-46 will increase the deterrence, detection, and conviction of those who engage in reckless and irresponsible conduct. Specifically, Bill C-46 will authorize police officers to use roadside oral fluid drug screening devices to help them determine whether or not a driver has drugs in their body. These are minimally invasive handheld devices that will expediently analyze a sample of oral fluid. If a police officer has reasonable suspicion that a driver has a drug in his or her body, they would be authorized to demand a sample of oral fluid for analysis at the roadside. A positive result on the drug screener would be highly indicative of recent drug consumption and could lead to further investigation, either by a drug recognition evaluation officer or through a blood sample taken by a qualified technician. In addition to authorizing roadside drug screeners, Bill C-46 will also create 3 new driving offences of being over the legal drug limit within 2 hours of driving. This type of offence is similar to the offence that prohibits driving over the legal limit for alcohol, otherwise known as the over 80 offence. These offences will be proven through a blood sample, which provides the best and most reliable evidence that the drug is active in a person's body. The bill provides that a police officer can demand that a blood sample be provided by a driver when they have reasonable grounds to believe that either a drug-impaired or legal limit offence has occurred. These offences will facilitate the prosecution of drug-impaired drivers by setting strict limits for the amount of drugs one can have in one's body behind or while behind the wheel. As I've previously indicated, the actual legal limits will be set by regulation, and the proposed drug levels were recently published in Part 1 of the Canada Gazette for public comment. On that note, 3 legal drug limit offences are proposed. There will be a straight summary conviction offence, which reflects our government's precautionary and public safety approach to THC consumption and driving. The draft regulations proposed that only cannabis, in particular THC, will fall under this offence at this time, and this offence will apply if a driver has between 2 and 5 nanograms of THC per milliliter of blood within 2 hours of driving. Bill C-46 also proposes 2 hybrid offences. One of these offences will apply to drivers found with impairing illicit drugs. For example, it will not be permitted for a driver to have any detectable level of cocaine or LSD in their body. This same hybrid offence will apply to drivers with levels of legal drugs that are expected to cause some driving impairment. For example, the offence will apply to drivers with 5 nanograms or more of THC per milliliter of blood. Finally, the third hybrid offence will apply to drivers with a combination of an impairing drug and alcohol, recognizing that combining drugs and alcohol can increase the impairing effects of both substances. At this time, the draft regulation only proposes levels for alcohol and THC in combination, but in future, other drugs could be added. It is proposed that 2.5 nanograms of THC per milliliter of blood in combination with 5 milliliters of alcohol in 100 milliliters of blood will constitute this offence. Some witnesses who appeared before Standing Committee did not support this proposed approach. They expressed concern that the science with respect to THC in particular was not clear enough to justify setting legal limits. However, let me be perfectly clear. One thing that all witnesses agreed on was that THC is an impairing drug. Our government is aware that, unlike alcohol, it is difficult to correlate the blood concentration of THC with impairment. That is why a summary conviction offence was proposed for the 2 to 5 nanogram range. As indicated by the Drugs and Driving Committee in its final report to the government on this issue, setting the legal limit at 2 nanograms per THC milliliter of blood will reflect a precautionary and public safety approach, one that strikes the right balance between the science of measuring THC impairment with the real risks associated with driving after consuming THC. By adopting this lower level THC level through Bill C-46 and the regulations, our government is signaling that Canada will not tolerate driving after consuming impairing drugs. I would like to add, Madam Speaker, that the new per se offences for drug-impaired driving contain several inherent protections to avoid charging drivers who are not actually impaired. These protections include the requirement that the officer in question develop reasonable suspicion of drugs in the body of the driver before administering the roadside drug screeners or other roadside sobriety tests. Where the driver fails the drug screening test, this itself is highly indicative of recent consumption, and ultimately the officer must have reasonable grounds to believe an impaired driving offence has been committed before arresting the individual and carrying out further testing at the station. To sum up, Madam Speaker, the drug levels that are proposed for these new offences are consistent with the approach taken in other jurisdictions, and I am confident that they reflect the best available scientific evidence. while at the same time ensuring that we are proceeding in a manner that protects the safety of the public. Madam Speaker, I'd like to spend my remaining time addressing other elements of Bill C-46 that propose to reform the alcohol-impaired driving regime. In this area of the criminal law, which perplexes even the most seasoned criminal professionals, this area has developed in a piecemeal fashion since the first offence was enacted in 1921. It has never been comprehensively reformed, and according to a 1991 report by the former Law Reform Commission, its provisions are, quote, virtually unreadable, end quote. This state of affairs cannot be permitted to continue, especially in the area of criminal law that is amongst the most litigated. Bill C-46 proposes to create a clear, simplified, and modernized legislative framework to ensure that the public can better understand the law and also ensure that the police can effectively enforce it. Another element proposed in Bill C-46 is mandatory alcohol screening. In my view, this proposed reform is the most critical reform respecting alcohol-impaired driving in this bill, and Mothers Against Drinking and Driving agree. In May of 2017, Andrew Murray, the Chief Executive Officer of MAD, said the following, quote, simply put, mandatory screening is one of the single most effective ways Canada can reduce impaired driving. It has been in place in many other countries for years and has helped them reduce overall road crashes and fatalities, end quote. Madam Speaker, mandatory alcohol screening represents a significant change to the Canadian law of impaired driving, but it is a tool that has been used in many other countries, as I said, for several years. It was pioneered by the Australians in the 1970s with great success, and more recently it has been adopted in several European jurisdictions, including Ireland and Scotland. This proposed element was the subject of much commentary and debate at the Standing Committee, and I thank all those who presented on this topic for their thoughtful and insightful comments. Madam Speaker, under the current law, a police officer at the roadside must have reasonable suspicion that a driver has alcohol in their body before they can demand a preliminary breath sample. Although this is a low threshold, the Standing Committee heard from witnesses who confirmed that a driver is often able to conceal visible signs of impairment from the police and thereby pass through a traffic stop undetected. The number of impaired drivers who can escape detection is simply astounding. In my view, this significantly undermines the detection and enforcement efforts of police, as well as the public messaging with respect to impaired driving. If more than 50% of impaired drivers are able to escape detection following a traffic stop, then a new approach is absolutely needed. The chief concern raised by witnesses with respect to mandatory alcohol screening was that it would lead to racial profiling. While I strongly condemn racial profiling, I am confident that mandatory alcohol screening will neither facilitate nor encourage this conduct. In fact, Bill C-46 guards against this in a number of ways. First, the bill is clear that mandatory alcohol screening will only be authorized following a lawful stop. The Supreme Court of Canada has determined that police are authorized to stop any driver at any time to ascertain whether or not they are complying with the rules of the road, including whether or not they have a license and insurance. These stops are authorized both at common law and provincial highway safety or highway traffic laws. If an officer is acting within this authorization, then he or she would be authorized to demand a preliminary breath sample. Second, mandatory alcohol screening is most effective when all drivers know they can be tested. Under our approach, drivers will know that they can be tested at any time and at any place to ensure that they are not drinking and driving under the influence of alcohol. Finally, the Standing Committee amended the preamble of the bill to reflect the expectation that all investigative powers, including mandatory alcohol screening, must be exercised in a manner that is consistent with the Canadian Charter of Rights and Freedoms. While this is implicit in all of our legislation, Madam Speaker, given the concern expressed with respect to the potential impact of mandatory alcohol screening, I understand the motivation behind this amendment. I would now like to discuss two more key changes proposed in the bill. In particular, the proposed changes to the over 80 offence. Currently, this offence is committed if the driver has in excess of the allowable blood alcohol concentration while driving. The proposals in Bill C-46 would change this time frame so that it would be an offence to be over the legal limit within 2 hours of driving. The purpose of this revised formulation is to eliminate the risky behavior associated with bolus drinking, sometimes referred to as drinking and dashing. This is when a driver consumes a significant amount of alcohol immediately before or even during driving in an attempt to get home before the alcohol is fully absorbed. This proposed formulation of within 2 hours also has the benefit of limiting what is known as the intervening drink offence. This can occur when a driver consumes alcohol after being stopped by the police, but before a breath sample. This has the result of frustrating the breath testing process, and this is unacceptable. Some witnesses raised concern that this could criminalize people who have done nothing wrong, who have simply had a few drinks after arriving home after a long week. I would like to clarify that the bill provides for this scenario by proposing an exception to the offence that is intended to apply to cases of innocent, or is not applied to cases of innocent intervening drinking. Furthermore, in situations where a driver's breath is tested outside of the 2-hour window of the offence, a legislative formula is proposed to calculate what the blood alcohol concentration would have been at the time of the offence. I would like to thank the Standing Committee for their amendment to this provision, which clarifies that before a judge can resort to the formula, there must be at least 20 milligrams of alcohol per 100 milliliters of blood in the driver's body. The final element I wish to discuss aims to finally end what some have referred to as the disclosure wars. Bill C-46 aims to clarify the maintenance records of the approved instruments are not relevant in determining whether or not the results of the breath test are accurate. It is enough that the Crown disclose the test results, any error messages, and that the results of the calibration or system blank checks. Bill C-46 proposes many other changes aimed at improving the law of alcohol-impaired driving. The legislative backgrounder to Bill C-46 and the accompanying charter statement outline many of the key proposals, including the rationale and the charter considerations. If members have not yet done so, I would encourage them to review these documents. Madam Speaker, I am immensely proud of the reforms proposed in Bill C-46. I am confident that they will reduce deaths and injuries. I'm also grateful to all the witnesses who presented their views on the bill before the Standing Committee on Justice and Human Rights. In my view, the bill is stronger for their input. And in closing, Madam Speaker, I urge all members to vote for public safety and support Bill C-46. We must all work together to eliminate impaired driving and all of its tragic consequences. Thank you very much, Madam Speaker.
Questions and comments.
The Honourable Member for Bellechasse, Chemin-Lévis. Thank you, Madam Speaker. One important group that wasn't heard from is Families for Justice. Families for Justice are families of victims of road accidents, and they want there to be strong deterrence in Canada. They want people to know in Canada that impaired driving will not be tolerated. So when you have a mandatory sentence, that does deter people. When there's a 5-year sentence, for people causing death by impaired driving, that sends a message. Why did the minister not listen to Families for Justice and include that mandatory 5-year sentence for impaired driving causing death?
Honourable Minister of Justice.
Well, thank you, Madam Speaker, and I'd like to thank my honourable friend across the way for the question and for his substantive work in this area, and I have enjoyed the opportunity to work with him. I have had the opportunity to meet with several members of Family for Justice, and I would at this point like to acknowledge the significant loss that they have suffered and recognize that the intent of Bill C-46 is to ensure we do everything we can to promote safety and to promote responsible driving. In terms of the question that was asked around mandatory sentencing with respect to this particular piece of legislation, it has been found that the mandatory sentences are not the deterrence. What is the deterrence in Bill C-46, as proven and as has been supported by Mothers Against Drunk Driving, is the mandatory alcohol screening. And I would like to quote the National Mothers Against Drunk Driving president, Patricia Hines-Coates, who said, with respect to mandatory minimum sentences at the Justice Committee, who studied this bill, and I quote, "As a mom, as a stepmom, as a victim, I cannot support it. There is no evidence to support that this will actually make a difference. We know once we bury our children or bury a loved one, it's too late. We need to focus on deterring it before it actually happens." That is where mandatory alcohol screening comes into place.
And comments? The Honourable Member for Vancouver Kingsway.
Thank you, Madam Speaker. Well, I don't think you'll find a parliamentarian in this House who doesn't agree that we need to do everything possible to discourage and hopefully at some point eliminate impaired driving. As one of my colleagues said the other day, driving is not a right, it's a privilege. And the right of people to peacefully and safely drive on our roads must take precedence over any other person's right to drive while impaired. On the other hand, I think as legislators we do have a responsibility to make sure that this legislation is very carefully calibrated. The Supreme Court has told us that in Oakes and other cases. So my questions are on this new legislation around cannabis to the Minister. A number of people are suggesting that a reading of 2 nanograms of THC per milliliter of blood may not indicate present impairment, particularly with, say, chronic users of cannabis, maybe medicinal users who use cannabis every day. So my first question to the Minister is, does she believe that that measurement is an accurate measurement of present impairment? And second, I'm led to believe that many experts say that we don't yet have proper screening devices that can prove true impairment. So does she have any concerns that by adopting those standards, we may actually be giving criminal records to Canadians who are using cannabis and as her government is going to legalize legally, but are not actually...
Sorry, I have to allow for further questions as well. So just remember that this is a question and comment period. There's only a specific amount of time. So people should be able to, MPs should be able to ask those questions within 1 minute. The Honourable Minister of Justice.
Well, thank you, Madam Speaker, and thank you for the question and for underscoring that we all share the desire to keep our roads safe and to ensure we do everything we can to keep those who have consumed alcohol or drugs off our roads. In terms of the questions around the legal limits and around the drug screeners, we have been working very diligently with respect or with the Drugs and Driving Committee of the Canadian Society for Forensic Science, who have been working towards and providing us advice on drug limits, as well as ensuring that we have, at the time of hopefully royal assent for this bill, that we have drug screeners that are reliable and accurate. Drug screeners would not be approved for use by police unless they meet rigorous evaluation standards. We're confident that we will have these devices in place by the time that this legislation comes into force. And further, in terms of the legal drug limits, any level of THC is considered to cause impairment in an individual. We have 3 offences that we've introduced. We are taking a graduated approach to the offences, and we trust in the science, and will continue to ensure that we work towards securing and setting limits as the science evolves to the place where alcohol screening is at. This is an ongoing challenge, and we will continue to monitor it.
Comments? The honourable member for Niagara Falls.
Thank you, Madam Speaker, and I thank the Minister for her comments. There are a number of sections of this bill that actually do make sense, but overall, my question to the Minister, I won't repeat the comments with respect to making sure that people who kill somebody when they are drunk driving, that there's a penalty that they can and should pay. That being said, the Minister talked on a number of occasions during her speech and in the comments that we'd like to do something to reduce impaired driving, but yet she admitted in her comments that legalization could increase impaired driving. Wouldn't that in and of itself give the Minister pause that this is overall going to be a bad idea if you're even acknowledging, if the Minister is even acknowledging at this point that we will probably have more impaired driving on the roads? Did they take that into consideration when they brought forward these 2 bills, C-45 and 46?
Minister of Justice.
Well, thank you, Madam Speaker, and of course thank my honourable colleague for the question and his ongoing work in this regard. Of course, we took into account the reality and the impact of bringing in Bill C-45, the Cannabis Act, and its companion piece, this one, Bill C-46, to ensure that we have among the toughest impaired driving rules throughout the world. We are committed to ensuring, actually, might I say, that impaired driving and drugs and alcohol is an offence right now. We are working to ensure that we have the best scientific evidence, that we have the necessary oral fluid screeners to be able to detect at the roadside. We are committed to ensuring that we do everything we can to be able to improve, which Bill C-46 significantly does, and be able to detect more individuals that are behind the wheels of their car while impaired by drugs or alcohol. This is a real opportunity to significantly strengthen our impaired driving laws in Canada.
Questions and comments? The honourable member for Guelph.
Thank you, Madam Speaker, and thanks to the Minister for bringing this to the House today. My question builds on some of the questions from my colleagues across the way that were similar to questions that were asked during the debate on C-45. The timing of Bill C-46 and C-45, how they work together, is really my question to the Minister of the strategy of having Bill C-46 in place before C-45 to ensure that we have safe communities, safe people, safe roads, and the importance of the legislation, the way it's now being presented to the House, to be moving forward. If the Minister could comment on that, please.
The Honourable Minister of Justice.
Well, thank you, Madam Speaker. Thank you for the question. And I believe this question speaks to the previous question of the honourable member across the way in terms of the objectives of Bill C-45 and the objectives of Bill C-46, the Cannabis Act, and also wanting to improve the impaired driving laws in this country. The purpose, or what we're trying to combat, is the status quo right now simply isn't working with respect to ensuring we do everything we can to keep cannabis out of the hands of kids and the proceeds out of the hands of criminals, as well as ensuring we do everything we can to keep individuals out of the driving seats of their car while they've been consuming alcohol or drugs. The objectives of both of these pieces of legislation is to ensure that we move from the status quo, put in place significant laws and regulations to ensure that there is no question that the Government of Canada is tackling these really important issues and ensuring the safety of Canadians.
Reprise